Major breaking news. The United States Supreme Court has set the oral argument hearing date in the United States versus Rahimi Second Amendment case for November 7th. That's November 7th, 2023. It is coming up quick. Major news. Let's talk about what it means when we get back. Hey folks, I'm Mark Smith, host of the 4Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the A to Z book that lays out how the anti-gunners are intended to take away our rights from everything from political violence to red flag laws to wholesale and retail level gun control, banking issues, and so on. It's all contained in First They Came for the Gun Owners by Mark Smith. Check it out. All right, folks, major news. The United States Supreme Court has set the oral argument date in the United States versus Rahimi, the Second Amendment case before the Supreme Court, for November 7th. November 7th. The first thing to understand is that this is somewhat soon. This is somewhat quick. I'm not super surprised by this. I thought it might be a little bit later, but the court controls its own docket. I think this means anything in terms of how the court's going to rule? The answer is no. I do not think this gives us any information about which way the Supreme Court's going to rule, whether in favor of the Second Amendment, against the Second Amendment, for Mr. Rahimi, or against Mr. Rahimi. Keep in mind, there are ways to rule in favor of the Second Amendment while also probably against Mr. Rahimi. We'll talk about some of those geeky details down the road. There's a bunch of ways this can go down. It's a very complicated case in some respects. In some respects, it's very easy. In other respects, it's complicated. We'll talk about the details more in a bit. But the big news is that November 7th is the oral argument date. So what do you need to know generally about what's going to happen there? Obviously, basically the Department of Justice with the Solicitor General's office, one of the big lawyers for Merrick Garland's Department of Justice, will be arguing the case against the Second Amendment and in favor of the law 18 U.S.C. 922 G8. As you know, this is a law that is almost never used. It is used a couple dozen times every year. 18 U.S.C. 922 G8 is rarely used. This is the law that says that if you are subject to a domestic violence restraining order, which just means that there's a restraining order in place that says you don't misbehave for all intents and purposes, you are not allowed to have a gun during the pendency of that restraining order. Until it ends, you cannot touch a firearm, and if you do, it is a federal felony under 922 G8. This law is rarely enforced. I think there's maybe 20 convictions a year, maybe 30 convictions a year all across the entire United States. That is it. So the question is, why did the Supreme Court take this case? It's because the law was declared unconstitutional facially by the Fifth Circuit Court of Appeals down in Louisiana and Texas, and Merrick Garland recognized an opportunity here because on the record, it appears that Mr. Rahimi is a bad dude. He was involved in multiple shootings. He, apparently took his girlfriend's head and hit it against the dashboard. So this is a bad dude, according to the record. And this is the sort of thing where Merrick Garland, that Joe Biden wants to force the Supreme Court to either uphold the Second Amendment or to throw the Second Amendment away in favor of punishing this apparent bad dude. And of course, if they uphold the Second Amendment in a particular way, then what will happen is it will allow Joe Biden's Department of Justice and the Democrats to have a talking point going into the 2024 elections to say that the Supreme Court picked by Donald Trump and the Republicans is bad on women. Not only do they overturn Roe v. Wade and destroy the right to an abortion, they will also argue, of course, that they will even uphold gun rights over women who are being abused by men. So you see immediately how this political propaganda will work. So that is why Merrick Garland rushed this case to the front of the line over many other cases that frankly should have taken precedence. But Merrick Garland, as a political animal he clearly is, decided this was the case to push to the front, and that's what he did. So we're having an oral argument on this on November 7th. Now, some of the things to keep in mind about this is, at the time of the founding, there was domestic violence against women. Domestic violence is not a new phenomenon, yet at the time of the founding, there's very little gun control laws touching on this kind of an issue, which is one of the reasons why what the anti-gunners are trying to do is they're trying to redefine the problem to say, yeah, at the time of the founding, you had domestic violence problems, but what you did not have was domestic gun violence. Did you see that sleight of hand? Specifically, again, the anti-gunners are trying to change the term from saying, yes, you had domestic violence at the time of the founding. This is not a new phenomenon. But what is new and requires new laws involving gun control is that this is not domestic violence. This is now domestic gun violence. So they've redefined the term to say that domestic gun violence is a new phenomenon, and thus they can do gun control law today in the 21st century that would not be allowed at the time of the founding. That is a big argument the anti-gunners are advancing in this case. Of course, the other thing the anti-gunners are trying to do, which I predicted on this channel well over a year ago, which is they're going to try to embrace late 19th century gun control laws. As you know, they try to say because the 14th Amendment was adopted in 1868, which applied the Bill of Rights, including the Second Amendment, to the states and localities, they're going to try to say that they can look at 19th century gun control laws to narrow the scope of the Second Amendment. Of course, we've talked about this, including in my article in the Harvard Journal of Law and Public Policy. I'll put a link to it down below, specifically saying that is not the case because you can only have one interpretation of the Second Amendment. And since the Second Amendment was adopted in 1791, the way to interpret this properly, and the way the Supreme Court has always interpreted this improperly, not just with the Second Amendment, but with all other aspects of the Bill of Rights, is to say that you take the 1791 understanding of the Bill of Rights provision, in this case, the Second Amendment's right to keep and bear arms, and then you view the 14th Amendment as doing nothing more but taking that understanding of the 1791 Second Amendment and applying it to a new group of people. Specifically, the 14th Amendment in 1868 did nothing more than take the 1791 understanding of the Second Amendment and the text of the Second Amendment from 1791 and applied it to the freed African American slaves to give them rights that they didn't have beforehand, and to apply the 1791 understanding of the Second Amendment to a new group of defendants, meaning states and localities, as opposed to just the federal government, which, again, the Bill of Rights in 1791 only constricted the conduct and authority powers of the federal government. With the 14th Amendment in 1868, the Bill of Rights then constricted the authority and powers of the state and local governments in addition to the federal government. But again, the understanding of the scope of the Bill of Rights did not change from 1791 to 1868. And the one thing it certainly did not do, which is what the anti-gunners are trying to argue, is that the 1868 view of the Second Amendment is much more narrow and restrictive than the rights bestowed upon Americans in 1791. That's why they're trying to talk about late 19th century gun control laws, to say that just goes to show you that gun control laws were allowed, and 18th century gun control laws can be used to restrict our rights today in the 21st century. But as you know, many of those gun control laws in the late 19th century were racist in nature. They were designed specifically to go after the freed African American slaves, the freed slaves, the African Americans who were the slaves, and of course, a lot of this is motivated by racism. Supreme Court Chief Justice John Roberts has recognized things like this in, for example, the Espinoza case dealing with the First Amendment, where he rejected 30 state laws dealing with what were known as the mini Blaine Amendments. He said that 30 state laws in the late 19th century cannot restrict the scope of the First Amendment's religion clauses. So by extension, I'm saying, and I think this is clearly the case, that late 19th century gun control laws cannot restrict the 1791 scope of the right to keep and bear arms. Beyond that, you're going to see a lot of appeals to emotion. In this case, there's going to be a lot of discussions about women that have been killed with guns in domestic relationships. But as you know, the Supreme Court has already acknowledged in the Caetano versus Massachusetts case in 2016 that restraining orders are generally not followed. If you go back and you look at the 2016 Supreme Court case in Caetano, which dealt with whether or not stun guns, which by the way are not firearms, just going to prove the point that arms beyond firearms are protected by the Second Amendment's right to keep and bear arms. It's not just firearms, it's other kinds of arms as well. But stun guns is an example of this. And in Caetano, dealing with stun guns, if you look at this Justice Alito and Justice Thomas concurrence, they point out that Ms. Caetano acquired a stun gun after her ex-boyfriend repeatedly violated a series of restraining orders that were supposed to keep him away from her, but the restraining orders were not worth the paper they were printed on, and as a consequence, he kept coming around, and finally she acquired the stun gun and used it to good effect to keep herself safe. The problem was she was found with the stun gun by the police, which was illegal at the time to have a stun gun in Massachusetts, and that's how she was convicted. Ultimately, that gave rise to her being exonerated and acquitted, because the ban on stun guns was viewed as violative of the Second Amendment, because stun guns were in common use by Americans for lawful purposes and thus are protected arms. So the Caetano conviction was vacated and reversed, which is good news for Ms. Caetano. But the point of that case, for the purposes of the Rahimi situation, is it demonstrated that restraining orders simply do not work if you're dealing with an actual violent criminal. A piece of paper saying don't go near the girlfriend is utterly meaningless, if they're going to commit an act of murder, because if they're willing to commit an act of murder by principles of a fortiori, they will certainly do other things like engage in minor violations of restraining orders. That just is common sense. We understand that. And the Supreme Court recognized that in Caetano in 2016. The other point I want to bring, and this is something that I think it's important, I maybe should have mentioned this or even earlier in the video, but this is kind of important. One of the interesting things I'm curious about, as you know, I think the amicus briefs for the pro-Second Amendment community is due somewhere around October 4th, 2023. I went back and took a look at the states. Now, this is kind of geeky, but you come to the Four Boxes Diner channel to get some inside geeky baseball stuff that you won't find in other channels. One of the things that I'm very curious about is to see the number of states, the number of red states that will submit an amicus brief in support of the Second Amendment on or around October 4th, 2023. Let me tell you why I make this observation. If you go back, and I did this, I just pulled the brief in Nysurpa versus Bruin. In Nysurpa versus Bruin, which was decided by the Supreme Court in 2022, the following states submitted briefs in support of the right to keep and bear arms. I'm going to read them out loud to you. Arizona, Missouri, Alabama, Alaska, Arkansas, Florida, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Montana, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, West Virginia, and Wyoming all supported the Second Amendment in the Bruin case. Now, in the Rahimi case, we've only seen the briefs from really the anti-gun community, the people supporting the government. And the brief that was submitted by the blue states in support of the government and Merrick Garland are the following states: Illinois, the District of Columbia, Arizona, California, Colorado, Connecticut, Delaware, Hawaii, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New Mexico, New York, North Carolina, Northern Mariana Islands, Oregon, Pennsylvania, Rhode Island, Vermont, Washington, and Wisconsin. So as you can see, the point I want to make is this. In Bruin, you had a whole list of quote-unquote red states submitting briefs in support of the Second Amendment. We have already seen in the Rahimi case a whole list of quote-unquote blue states submitting amicus briefs on behalf of the government. Now, I should note that usually what dictates when a state submits an amicus brief is what the state attorney general. Now, sometimes you may have a state that has a Republican state with a Democratic attorney general. That does happen, and usually the Democratic attorney general is the one that dictates whether or not a state will submit an amicus brief in support of a particular issue in front of the U.S. Supreme Court. So I bring this to your attention because one of the things I'm going to be looking at on and around October 4th is to see how many of the states that I listed to you as submitted a brief in support of the Second Amendment. In the Bruin case, how many of those same states are going to submit a brief in support of the Second Amendment in the Rahimi case? Or are they going to run away because Mr. Rahimi is alleged to be a bad dude? He may very well be a bad dude, but Miranda was a bad dude, allegedly, and was convicted and gave rise to the Miranda warnings. Mr. Gideon was a bad dude, allegedly, and gave rise to, the right to counsel under the Constitution. And again, as we know from the McDonald case in 2018, Justice Alito points out that the entire Bill of Rights is designed to, in some sense, protect criminals and people accused, people accused of being criminals. And we really are bent over backwards to protect the rights of all Americans against government overreach. And when in doubt, you throw it out. When in doubt, as you know, the government loses. So it's going to be very interesting to see whether or not any of these red states or how many of these red states submit a brief in support of the Second Amendment, or do they run away and not do so on the grounds that they don't want to be accused of supporting a quote-unquote wife beater or a domestic violent abuser. Obviously, if you do engage in domestic violence, you should be put in prison. You should be deemed a criminal, convicted, and put in prison. That is a violent crime, and it is illegal. Murder, rape, robbery, assault, battery. These are malum in se, meaning evil in and of themselves crimes. And if someone engages in this, they should be punished. With that said, you do have due process rights and other considerations that go into this because, again, the point of the Bill of Rights, the entire point of the Bill of Rights is not to make the job of the government easier. It's not to make the job of the police easier. It's to make the job of the government and the job of the police harder to make sure our fundamental rights are protected. And sometimes bad people may slip through the cracks and they may get out from a crime they've committed. But that is a price we pay for freedom to live in a free society as opposed to a police state. We don't want to live in a tyrannical police state. And one of the checks and balances there is the Bill of Rights, including the right to keep and bear arms, as well as the due process rights, the right against self-incrimination, the right to a lawyer, and so on and so on. So nevertheless, I am curious to see what happens there. That is something we will be tracking very carefully. So if you're in those particular states that I mentioned that are the quote-unquote red states, you may want to reach out and make sure that your government, your state actors, your attorney general, your governor, whoever it may be, I don't know the details in every particular state, but you may want to consider reaching out and making sure the people in your state, especially in red states that are good on guns, you may want to make sure that they have their voice heard on behalf of the people of your state in this Rahimi case, and they don't skip out of town and not submit a brief and not show their support. Because I'm going to tell you, if that happens, we will be talking about those states that submitted a brief in Bruin but did not submit a brief in Rahimi, and we would be discussing that after October 4th when all the briefs come in support of the Second Amendment and so on. All right, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't followed me on Twitter or on X, please do so at Four Boxes Diner. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.